Today, I'm super excited to get to interview and talk with superstar lawyer Ben Cloward out of Nevada. So, really don't have to say too much more than the following about Ben, which was in 2016, in the entire state of Nevada, he was named the Trial Lawyer of the Year, which is really insane, dude, because there are some unbelievable trial lawyers in that state. And for everybody to recognize you as the top dog that year is really impressive. And the other thing that kind of blew me away about reading about that is that you graduated law school in 2008.
Yeah. Yep.
So you've only been practicing for 12 years at this point and have had all this success, which is just, I mean, it's really, it's so impressive. And, I remember hearing about you when I was super into the reptile back in the day. I think I was talking with like Chris Stombaugh at one of the events or something. And I was like, who are some of the other people that are, super zoned in? And I remember hearing your name. And then I remember hearing you on Panish's podcast last year.
Yeah.
And I was like, I know that name. I have to call this dude and just, introduce myself. And you were super nice to talk to me and give me some thoughts about the way you're handling focus groups these days. And I want to talk a little bit about that too. But in any case, thanks for joining me today, Ben.
Hey, I appreciate you having me, and really, I've been a fan of yours too. I know you're a major student of the law and major student of the techniques, and that's very impressive. And I admire your drive and determination to figure things out. And I think that's that's one thing that's super important, is just trying to figure it out.
Absolutely. And just, keep educating ourselves and trying to get better. So I wanted to, we've talked a bunch and emailed and stuff, but I still don't know a lot about your career and how you've gotten to the point where you are. So, just for the trial lawyer junkies out there, you've been practicing for 12 years. I heard on one of the podcasts, you started out at an insurance defense firm for a year. And then have you been at the Richard Harris firm ever since?
Yeah. So I had kind of a weird progression from Rick's firm. So I started off insurance defense. There's a well-known lawyer here in Vegas, a guy named Rob Cottle, a great trial lawyers, had some great success. He was Robert Eglett's partner for a little while, and actually Rick Harris's partner for a little while. But I remember when I was a student, it's a second year student, I was doing a summer internship at a defense firm. And Rob gave me the advice. He said, look, if you can work for a defense firm for 3 to 4 years, 2 to 3 years, you'll learn good habits and you'll learn, the proper way to do things. And I think that was more from just a procedural standpoint. And so I knew I wanted to be a plaintiff lawyer. And so I kind of took his advice and stayed there at that firm. And I remember I had a client that was a property owner, and I filed a motion to dismiss a plaintiff's claim, and it got granted. And the plaintiff wrote a letter to the firm, and I just felt terrible. I felt so bad what I'd done, and I just kind of had a thought of like, what am I doing? And so I switched over at that point, just said, I can't do this anymore. Started looking and landed with Rick and stayed there for about 6 years. And then I went off on my own with two partners, John Hicks and Allison Brazier, and did that for 2 years. And then when I got the trial lawyer of the year and those things, Rick said, hey, why don't you come back as a partner and we'll have you help with the litigation and do those things. So that's kind of the progression of my involvement. And so now I'm still just at Rick's, just kind of hanging out now.
Yeah, sure. Hanging out. So how many, it sounds like this, veteran long career, but again, that was only in the course of 12 years you've accomplished all that. So in that period of time, how many cases would you say you've tried to verdict at this point?
So I've tried. I think on my Abota list, you have to keep a tally. I think it's 35,
Yeah.
35, 35 trials. It's close to that. I need to update it, but last I checked, it was around 32, 33, and I've tried a couple cases since then. So
Because you get the next bump up at 50 for a Boda, right?
that's right. I think it's something like that. Their point system. It's now it's not the number. It's the points.
Okay, right, right. I'm at like 36. I'm right around where
Oh,
you are.
nice,
Gonna
sweet
have to
man.
do the same thing.
I'm chasing you, brother. I'm chasing you.
I might be trying one in November, so I might get another one under my belt. So, tell me about how your practice evolved, your approach to trials evolved from the time that you first started trying cases. I mean, your first one, were you thrown into it? Did you not know much, or had you, worked with other attorneys and had a pretty good sense of what you were doing? Where have things gone for you over time?
Sure. So when I joined Rick's firm, first off in the defense, I didn't get any experience.
No way.
I was like the fourth guy on the the totem pole or whatever you want to call it,
Yeah.
and so I didn't even get to go hardly do depositions. Completely opposite experience at Rick's. Rick's, I start there and basically, you get a caseload of 50 litigated files and 150 claims files, and you can really just do whatever you want with the files. Well, I always knew I wanted to be a trial lawyer. And so I think within 2 or 3 months of starting at his firm, I did my first jury trial. So I was about a 1-year lawyer. I did it alone. The guy, I'm not going to say his name, but there was a guy that was supposed to sit second chair with me, and he didn't even show up. So, first jury trial, I'm down there, you know, and it was against this lawyer in town that's very well known. That's a great lawyer, and so I was just down there trying to figure it out. And I think, the biggest thing I've always felt like is that's the very most important was the jury selection. Figuring out the jury selection and I think as I look back on those early trials, I didn't really know a tremendous amount of what I was doing from the science standpoint or from a technical standpoint. I just knew it was important to build a relationship with the jurors. But some of the early cases I tried, I always joke with people and say, hey, look, I got my start and my attitude was I'll try a bologna sandwich. I look at the first few cases that I tried and I'm just like, man, what was I thinking? But I had no fear. And whether that's no fear or just being stupid, I believed in the cases. That's one rule that I've always had is never, ever, ever try a case that you don't believe in. And so if I don't believe the client, or if I, think that they're not telling the truth, or if I, whatever it is, if I don't believe what the client is telling me, I will not try the case. Because I think that's a disservice to everybody. I think it's a disservice to our profession. I think it's a disservice to the client. And so that is one rule that I have had, but I've tried some really tough cases. I had a case where a client I tried, unfortunately, we were not successful. She had 0 property damage, 0. In my opening statement, I basically, I embraced it, embraced the suck and said, ladies and gentlemen, the reason we're here is I'm so-and-so's attorney, and this property damage here, and I'm holding up a poster board. I can't even tell you where the damage is, and that's why we're here. But in that case, she had a very well documented injury. She had a case with our firm prior to that where it was well documented. It was isolated to her back. And then immediately after this low impact crash, that was exacerbated. Now she started having a radicular component. And so I just felt like, you know what, she's telling the truth. this was a minor impact, but she was injured. We had a lot of other issues in that case that kind of, made it impossible to try. But, we certainly, we tried, and it was a split verdict. It was a 6-8 decision for the defense. But, you've got to try those cases. I think that's my approach is that you have to figure out how to win the tough cases. If you can figure out how to win the tough cases, it makes it so much easier when you have a case that doesn't have all of the warts and all of the other issues. And so I never shied away from those really, really tough cases. I tried to figure them out. And I think that's important for young attorneys.
Yeah, I am a big believer in the same way. It was just by chance, the firm that I started out with, I was not a very good student and I didn't know what I wanted to do. And I just kind of fell butt backwards into a personal injury practice and no clue what I'm doing, and got thrown into a trial. It was a medical malpractice trial of all things, like 6 months in. And I mean, I didn't know evidence. I didn't know anything. And it was the most ridiculous case ever. But again, I was looked at the case, and little that I knew about medicine, I did believe that my client was hurt because of the situation. But I remember trying the case and just like falling in love with the fact of like the whole idea of it, like just being there in this room and realizing even though my case could never have been won, realizing the importance of the whole process. And one thing that I think, in addition to the importance of trying, as you put it, I'm the same way. I'll try a bologna sandwich. I mean, you give me a case that there's even a shred of something that I can sink any teeth into, no matter how bad the other facts are, I'm all about it. Let me get in there and give it a shot. But I find sometimes nowadays, if I'm preparing for, bigger cases, and there's a lot of anxiety, I always feel a lot of anxiety and stress getting ready for them. I don't want to let the client down. I worry about, what will people think if I lose and stuff like that. I find that I get the most confidence of thinking about the really impossible cases that I almost won but didn't.
Yeah.
I don't know why, but I'll think to some case that had just the most ridiculous facts, and I still say one negligence, maybe lost causation on a split jury or something, and that gives me way more confidence than thinking about good outcomes that I've had at trial. I don't know why, but
I agree with you. I actually, before this recent big verdict that I had in February, I tried a case in, I think it was November or December of 2019. So I was coming off the heels of a loss. It was a trip fall case where my client had, he worked in the mall for multiple years and walked past this particular pillar every single day of every day, Monday through Friday, 3 or 4 times a day, coming in for work, on his break, on lunch, multiple times. Well, this day he wasn't paying attention and tripped over the corner of this pillar. And I mean, we had the jurors initially for after, I think it was a day of deliberations, they sent out a note and said, we're a 6-2 verdict for the plaintiff. But we had a question. We've got a question about this or that jury instruction. Well, what ended up was that 2 of the jury instructions somehow were mistakenly not given that were our jury instructions. And it was just crazy. The deliberation went on for another day. They sent out a bunch of other notes, and then it was like, 5-3 for the plaintiff. And then it was like, it was crazy, but the judge allowed a replay of the defense expert. And then after the defense expert gave,
that's terrible.
Yeah. Then they came back with a 2-6 defense verdict. But, I look at that case and I just think, man, we almost won that. And the reason for it, I mean, again, I believed in the case because, there were some different things that had taken place at the time he tripped. They were doing some construction in the mall, and so they kind of narrowed narrowed the walkway, and some other things like that, some other factors that I think that the store owner just didn't take into account. And so we felt good about the liability, and felt like we were gonna, but now I look back and I say, he walked past that probably 2,000 or 3,000 times.
Like he literally had to have not been paying attention for the event to happen.
Yeah.
But it doesn't change the fact that it either shouldn't have been there, or there was, factors on the defense that, could have prevented it, from Jump Street.
Yeah. Yeah.
Did you focus group that case a lot, or jury analyst, any big data stuff on it?
We didn't do big data, but we did do focus groups on the case. We always knew that it was going to be a tough case. We did, I think, at least 2 focus groups on the case. But unfortunately, it was a situation where it was a no offer case. And I think the highest offer they made was $500, so it was, and he had a nasty injury. That was the one thing that I felt like, at least, we're not going to be fighting the causation, was that he had a broken hip, required surgery. And so, it was kind of like, hey, if we could just get past this liability hook. And, and one other reason that I felt like trying the case was, we never really believed the defense, and we found out actually after, which is the subject of a motion for a new trial, that they had kind of withheld some information about these columns that my client tripped over. We always felt like there were more incidents, and they didn't turn them over. We actually turned over some kind of mid trial. The judge ordered them to turn them over mid trial, and so it kind of changed the dynamic of the way that we picked the jury. And I still think, had we had all the information, we would have sequenced our presentation a little differently, and we'd have just done some things a little bit differently in that case. But I did learn a huge lesson, and this is a huge lesson. Hopefully it doesn't take 34 jury trials for young lawyers out there to get. But one of the things that I felt like the defense lawyer flat out lied to the jury in opening statement. And it really made me upset. And I allowed that kind of being upset to influence the way that I was. And that was a huge lesson for me, that you can't change who you are. You can't, depending on your persona, whoever you are in the courtroom, you've got to be that person all the time, and I think I let my emotions kind of get me a little bit off track, because I was so upset that the guy just ball-faced. It wasn't like an innocent lie. It was a ball-faced lie. And it really upset me. And I think it influenced me a little bit.
Yeah. I mean, I think a lot of trial lawyers deal with that. I know over the years, have really focused on, I'm not a Zen guy, but trying to get into my own personal kind of Zen state when I try cases, because, everybody's impression in the case, and certainly yours as the trial lawyer, is so critical to how the jury receives and just feels about the case. And now if you come off, and even though you have every reason to be angry, you're now maybe the jerky lawyer or the kind of over aggro attorney. And every time I try a case these days, I always go back and read Friedman's on becoming a trial lawyer. It's like my Bible. It just connects with me so much. And I always find new stuff that whenever I reread it, and he has a section in there that's apropos of your comment about emotional equilibrium, and talks about a phenomena basically that's recognized in psychology, but you can see it. It's if one person's emotions go up, there's sort of a counterbalance of emotional response to other people around. So like you can imagine, husband and wife at dinner, and husband has a hair in his soup. and he goes ballistic. Maybe they were both upset at first, but then he's going ballistic with the waiter. Now wife is going to go, more kind of, more passive. It's okay, kind of the opposite. And juries are like that.
Yeah.
If we're the one getting in there and flipping out and getting all angry and stuff, then, we're kind of, taking the angry oxygen out of the room from the
Sure.
jury, I think.
Absolutely. No, I completely agree. And that was a major lesson for me, as I reflect back on that and kind of deconstruct, what are some other things? Because we were so close, we were just so close. But, another thing, because I know you love talking about all things jury trial, but another lesson that I learned in that case was something that was just completely took me by surprise, was the forgiveness that the jury had to the defense lawyer when he got up there, and I hammered him in my closing, and I think that I was maybe too aggressive, obviously, because I always love when attorneys, they distort the opening statement. I love that. And I'm happy when they do it, but this was such a ball face. It wasn't a distortion of the truth. It wasn't a twisting of the truth. It was just a flat out lie. And it bothered me. And so in my closing, I kind of hammered him. Well, he gets up there in his closing, and just in a moment of complete, and this is an old dog. I mean, this is a guy that's tried 150, 200 cases. He's practiced for 50 years. An interesting story. He actually was, when Rick Harris, my partner, when he went through law school, this guy was one of his, I think, professors or something like
wow.
that. Yeah. So this guy is old time lawyer. Way back. So he gets up there in a moment of just complete, genuine, own it, like, ladies and gentlemen, I was wrong in my opening. When I told you this and this, I was just wrong. And I thought that I had the facts, and I clearly wasn't right. And, even his apology, he basically, what he said was that, because we had one prior incident, some lady tripped over the corner of this base, and he said, this lady, she comes into the mall and she was running through the mall, and that's why she tripped, and she's running through. And I'm like, this is a 80-year-old woman. She ain't gonna be running anywhere, And so, but he just owned it, embraced it, and moved past it. And the jurors I could watch their body language. I mean, when he kind of got up there, they were kind of expecting, and it was just like, okay. And they moved past it.
Yeah. And there's such a big lesson to learn, I think, that we can take away if, God forbid, you do everything you can in your preparation to prevent any, inaccuracies or, problem testimony or really bad impeachments and stuff like that. But, from time to time, either you miss something or something happens that you never saw coming. And I think that's a great lesson to see. You saw it firsthand.
Absolutely.
How powerful it was for him to just legitimately, incredibly own it.
Yeah.
And it was like not an issue anymore.
Yep.
Yeah, I had a med mal that my partner and I tried a couple of years ago. That it was a really tough case. But there was an issue that came up in the way that our client had testified. And, if I'm being brutally honest about it, I didn't prepare my client well enough on his medical records. And, he had testified about one thing, and then his record really showed something else, and it didn't come off well, and it felt bad. And I don't know what would have saved the case, but I was disappointed in myself after the fact, because in closing, I didn't really address it. You know what I mean? I kind of danced around and then skirted it, and I really should have hit it on and taken it on. The truth of it was, that's my fault. That was something in the record. I don't think it's particularly accurate, but I should have prepared my client. I should have been upfront with all of you, but I didn't do that. And, I think it would have made a big difference.
Yeah.
So what let me, selfishly ask you this. Do you, these days, over the last, say 10 or so trials, you've had so much great success. Do you have any kind of go-to, damages arguments that you feel are working really well for you, or do you kind of, and I guess what I'm saying, do you have any sort of, your set pieces that you argue? Maybe you don't do them in every case, but you have them for different scenarios, and any that you think are working real well for you these days.
I do. There is an argument, and I'm just, I ripped this off from Keith Mitnick. He's got a podcast, Don't Eat the Bruises, the Dignity of Damages segment, I think is very, very helpful. And I think just getting the jurors to realize that, look, the damages that are, it's not about, and I think, and I had argued this in different ways, but it wasn't really as effective as the way that Keith does it. But it's kind of just really talking about, look, at the end of the day, it's not about what you're giving my client. Okay, there might be some folks in the jury room that are going to say, well, hey, geez, we're going to, plaintiff wants us to give his client $1 million in pain and suffering. It's not about giving the plaintiff anything. Okay, it's about compensation for what has been taken away. And Keith talks a lot about that word taken, how it's just such a loaded word. Nobody likes to have anything taken from them. My little kids, you look at, I don't know if you've got kids, but my 11-year-old doesn't want to have any of her toys taken by my 5-year-old. Same thing. Yeah. My 5-year-old doesn't want to have anything taken from, and I think that there's just, when you reframe that just slightly, and I've done a whole bunch of different, closings, and I've actually done closings. Rick Friedman does a wanted ad. Mm-hmm. He turned me on to a wanted ad. I tried the wanted ad. I've used that several times in the closing argument. And I think the main thing is to just be knowledgeable of a bunch of different ways to argue damages. And when you are in the situation, use what feels appropriate for you there. So for instance, the wanted ad was an argument that I used. I mean, Rick's always been just amazing. He's an influence to everyone. And I remember as a young lawyer, I had a case that was going to trial, and I think it was like maybe my, second or third big trial. And it was a case where they had stipulated to damages just right before, like a day or two before the trial was set to begin. And I think I called him, I sent out a text message or an email to him, and I'm not going to say who the other lawyer is, but to another nationally known lawyer, just saying, hey, I've got this case, and I'm in trial, because I think they actually stipulated during jury selection, to the judge, they said, hey, judge, we want to stipulate. And so judge said, okay, come Monday morning, when you guys are doing your openings, Cloward, you don't get to talk about all the liability stuff. And so it was like, I sent out this panicked email, and the email was like, hey, this is what happened. How can I address this? And Rick's like, here's my cell phone. Call me on Saturday. I'm available from this time to this time. The other lawyer was like, go buy my book and read chapter 12. Something along those lines. But the point of it is, it's reaching out to other people and trying to figure out what works and when it works. And it was early on that Rick gave me, he said, hey, you might also, because I was asking him, well, also, while I've got you on the phone, what do you think about pain and suffering, and how do you argue that? And he sent me the wanted ad closing argument, like a segment where he'd given it. And so I've tried that, and I've tried a whole bunch of other things. I've actually been pretty creative, and I used to bring scales into the courtroom. And on the scales, what I would do is I had those mini cereal boxes. I
Oh yeah.
wrapped them all up in white, so that it looked like just little white bricks, right? And I had this really nice scale I got from Restoration Hardware, and on the one side, and I would have, based on my client's testimony, I'd have these scales that I would put, can't get in the shower alone, or can't tie your shoes, whatever the very specific injuries were, and I put those on the scale, and it would basically level it out. And I would say, now, ladies and gentlemen, your job is to decide, what is it going to take to even the playing fields, to put her back in the position that she was prior to this case. And so I would put like 50,000 on there. Let's say this, is 50,000, is that going to do it? And you go back and you talk about this in the jury, and you say, absolutely not. I mean, look at all the things that she's lost, and so then I would put, more, and would change it. And I would get to a point where I would have, a range of whatever I felt like was the appropriate amount. But so I've tried that. Didn't have a lot of success with that, but that was something that I did, that I created early on. So
Yeah.
I'd be kind of curious to go to maybe revisit that and see if I had any success. I mean, that was something I did in the first, 5 to 10 jury trials, and I never kind of went back to it.
Right.
But yeah, I think just having a whole bunch of different ideas, finding out ways that, Rick Friedman and Nick Rowley and a lot of folks argue them, and have those ideas kind of stored in the back of your mind, so that when you're preparing that particular case, you kind of think through what would be most appropriate for this case.
Yeah.
And then tailoring your arguments to that particular case.
I love how, you, and I've heard it a million times, and it's true. It's like, you stand on the shoulders of giants, and everybody is ripping off things that somebody before them did. And
most of them, it's Mo Levine. Right?
Exactly.
Most of them, it's Mo Levine.
From what I can tell, all roads lead back to Mo.
Yeah.
But it's cool when people have their own different takes on it. And then when there's that kind of synergy between different argument pieces, and maybe they uniquely click for you, or you see the connections between two different people. And the one I thought was really cool, because when I hear a new argument piece or something, like there's like nothing I'm more excited about. I'm like, man, I can't wait till my next trial to use this and try this out. Sometimes, to your point about, you got to figure the right one out at the right time. I've been so excited to use something. It was like clearly not the right time to use it, but whatever. So there was there's that argument that's been around, probably forever. And I've heard versions of it, like, the evil man in a limousine pulls up and time stops and stuff. Yeah. And then, and then my friend Bob Simon out in LA had sent me some PowerPoints years ago where he was doing a version of it. And then I heard Nick Rowley do one on the Trial by Human, the subscription video service. He did one to like the Vermont Association of Justice, and he did his version of it, which really, really clicked with me. Like, cause he had kind of the constitutional component, about, life, liberty, pursuit of happiness. And then he transitions into, the just kind of the knock at the door type thing. And then I heard, on Mitnick's Brushstrokes podcast, he was doing another version of it, but his was, we're not a barbarian society, so it's not eye for an eye justice, but it's also not, we also don't turn a blind eye to justice, because that would be no justice at all. And then he goes into the Constitution aspect of it. And it was just really cool, because I thought, basically nobody does as well as Mitnick with these like turn of words and these phrases he uses that are just so good. I was like, man, is that clever? We're not eye for an eye, but we don't turn a blind eye. Like, so great. But then how that then combines with all these other arguments. And I used that exact format in my most recent trial, and it felt really comfortable. but to your point about, I wonder if my bricks on the scales argument would work better now, maybe with, just your ability to better massage it in closing, and maybe in your bigger case, it might be effective. I, you know, I'm always still wondering, because I like the science aspect of stuff and I hate stuff that's anecdotal. Well, is this argument even work? Is this even effective? Just
Yeah.
because somebody got a big verdict and they use that, I mean, so what? But I can tell you, and again, this is still very anecdotal and microscopic sample size, but in two different cases that I got good verdicts in cases in the last couple of years, I actually had jurors, call me that wanted to talk about the case. And I was like, oh, so tell me about the jury deliberations. And in two separate cases, I had jurors in that setting specifically on their own bring that argument up.
Wow.
And indicate how it really helped them to think about non-economic damages. You know what I mean? And then, because I think it also really ties into the point you were talking about, the loss aversion, the taking away, which is a powerful concept. And if you can tap into, yeah, I've got kids, and if you saw my 4-year-old, you try to take any food off his plate, he'll go ballistic. And that's just primal, and it's hardwired into our heads. But I just think it's so cool that stuff all works together. And I think that argument, and I also know from so many different people that the want ad, or the ad in the paper argument, that's really, really effective as well.
Yeah. Yeah.
So anyway, hey, couple of things I wanted to talk about. So, as in your most, I mean, I know you've had, multiple 8-figure verdicts, but there was this, the first transit case where this poor guy, choked to death on the bus. And then more recently, your Sportsman Royal Manor negligent security case. Can you talk to me a little bit about, the way that you, I'm assuming in First Transit, you did big data, or you did a lot of focus groups for that?
We did a lot of focus groups. We didn't do big data.
Okay. All right. So one thing I really wanted to pick your brain about was, when I heard you on Panish, and I even asked you a little bit about this when I called you, you talk a lot about the power of sequencing, and that you seem to glean how best to do that from your focus groups. And I mean, could you share with me a little bit, like, what's the process? I mean, how many focus groups do you have to go through do you think, to best figure out the sequencing, and how do you do it? I mean, how do you carry it out in a focus group?
Absolutely. So the way that it kind of came about in the Chernikov case, and I was very fortunate. My co-counsel in that case is Charles Allen, who's a brilliant strategist, brilliant legal mind, just a great human being, dear friend of mine. I call him my big brother. Charles and I spent, I think it was like 18 days together, 15-hour days, didn't have a disagreement, didn't have a fight, didn't have, it was just like bliss, just listening to Bob Marley on the way to the courtroom and back. And, but in that case, we've done a lot of focus groups, and we had the death on video, and it's just profoundly impactful watching this poor, and he's a 51-year-old mentally challenged individual, watching him sit 4 feet away from the bus driver, slowly choked to death, while the bus driver was just not even paying attention to the only passenger on the bus. So we had that, and we wanted to see, I guess, the first few focus groups, we sequenced it with that front loaded, and just thinking, hey, people watch this video, and how we're going to win them over right then and there, and that's just the way that it's going to be.
Well, let me jump in just for a second so I better understand. So when you do that focus group, so your early on ones, do you give the jury like a little brief summary about the case, or do you just say, hey, I want to show you a video, and then we're going to go from there?
As I recall, and keep in mind, this has been, 6 years ago since we did those, but I think we would have given them a brief kind of overview of the case and kind of showed them the video and then kind of started to talk through some of the issues. And then, you know, I always like to ask the jurors to vote on liability and vote on damages. And I think that this is an important thing to do that everybody should always do, is to ask each individual to write down their allocation individually, write their name on the top, fold the piece of paper up, you know, let them know no one else is going to see it, fold a piece of paper up and send it on up to you, and then gather that information. Because it's always interesting to see what the individual decisions are versus the group decision. You know, because group dynamic and group decision making is obviously a huge factor, and it also lets you know, kind of gives you an idea, helps you to spot, helps you to learn how to pick out who the leaders are. Because if you've got a guy that maybe they vote, you know, $50 million and 100% negligence, but then the group decision is defense verdict, clearly this person is he's not a leader. He's a follower. He's going to do whatever he's going to do. But it just kind of helps you as the lawyer start to figure out who's going to be your leaders and who's going to be your followers. It just helps with that process. But what we did is we showed the video and showed a few other slides and different things. And what we were finding is that people weren't really receptive, and they weren't given big numbers, and it was like, you know, high comparative numbers. And so we switched the sequence up a little bit and said, okay, well, let's talk about, let's start with the rules, the rule violation. And this just goes back to basic, what is the conduct that you're facing or that you're focused on? Are you focused on the defendant, or are you focused on the plaintiff? If you're focused on the defendant, the jury verdicts are going to get much higher, going to be much better, because that's what the focus is. And there are a lot of examples that people give with that. But what we found is when we focused on the defendant and really stayed focused on the defendant, and then at the very end showed this is the result, this is what happened, it was just like, that was the sequence to do it. So that was the big kind of lesson for me of the power of sequencing. And so after then, I've always been hypersensitive to sequencing and what is the most important or the best, most effective way to sequence things. And so I spend a lot of time on that. And when should I introduce a specific fact? When should I withhold a fact? When should I, you know, and I've used the big data to help me with that decision. And if you want me to talk about that next, I can do that.
Yeah. Let me, so before we get into big data, because you were sort of referencing that, you know, the focus of judgment, focus on the defense, you know, which was first beat into my head, you know, reading, I don't know, whatever, like the first version of damages. And because at that point I was just like, somebody tell me how to do an opening statement, you know, for heaven's sake, because I was really lost in the weeds there for a while. And then I found my way into reptile and, you know, now edge and whatnot. But, you know, and that was always, you know, I think, you know, there's like these kind of rules of thumbs, these heuristics about trying cases, and especially from, you know, an opening statement and an argument, at least as the case transitions, you know, that focus of judgment on the defense is such a hugely important idea. And that was a big windup to asking you, in your opening statements these days, are you following a relatively similar, you know, skeletal outline, or are you mixing it up different ways depending on, you know, what's, you know, what the, you know, the focus group or different prep is telling you?
Yeah, you know, I never ever felt comfortable with the reptile / ball opening. It just, for some reason, for me, it just didn't feel natural, and so I've never used it. And my general rule of thumb is to spend 2/3 of the presentation talking about the defendant's conduct before you hardly even introduce your plaintiff. And so that's really the only rule of thumb that I have. And I like to just, I think it helps the jurors just kind of chronologically. And, you know, in a lot of these rear end type cases, it's hard to vilify a defendant. You know, sometimes when it is maybe kind of a subtle mistake, or, you know, whatever, maybe they weren't paying attention. Now obviously you have those cases where they made a lot of decisions, but, you know, if you've got the soccer mom that just looked down for a minute and hits the client, you know, that's a hard case to vilify. And so what I've tried to do is focus on vilification of the process. And so my villain, and Jerry Spence, you know, the thing I've learned from the TLC, trial lawyers college, is you have to have a villain in every story.
And betrayal and
betrayal. Yeah, you have to. You just, you know, just, and so I see some lawyers that try and, you know, they'll get the defendant in a depot and sit and turn them in all these knots and try and get this and that. And a lot of times it's just, look, I made a mistake kind of a thing. And they'll try and really villainize that person. And I think, look, you're doing everybody a disservice, because you're basically, you're so on code that you're the jerk lawyer that nobody likes. And so what I've done is really tried, and one thing that I love is Rick Friedman's moral court advocacy.
Love that presentation. Yeah.
And he says, what's the real truth of your case? Well, the real truth of the majority of our cases is that you've got an insurance company behind the scenes that you can't talk about, that they just want to nickel and dime your client. They don't want to give fair compensation to your client. And they're using the defendant and, you know, the process to deny your client. And so I've tried to really think of ways to, without violating the rules, staying safely within the rules, don't, you know, even get borderline on the rules, try and stay safely between the lines of the rules, but to talk about the process. And so, you know, I'll focus on, here's this crash that takes place. And, you know, the defendant, John, admits at the scene that he was at fault, tells the police officer, I wasn't paying attention. And there's no dispute. And everybody leaves thinking, okay, John has admitted liability. That's the problem, you know, and he created this. He was the cause of the problem. Well, then what happens is a day or two later, he goes and talks to some, and in our state, we can talk about agents working on your behalf. You just can't mention insurance, you know.
But you can say, like, talk to this person and they figure it out. Yeah.
Yeah. So he talks to some folks that are working on his behalf. And now all of a sudden, the story starts to change. And the denials start to come. And that's why we end up having to file the lawsuit. And you'll notice when we file the lawsuit, we allege, and I've preached and preached and preached, when you file your complaint, don't have this legal, you know, as one defense lawyer says, this legal mumbo jumbo, you know, just have it be basic stuff like, defendant was driving a red this, defendant, you know, ran into my client. Just very simple allegations. And I even have some of my complaints now where it's like basic facts and then, you know, like lawyer language or, you know, legal issues. And so the legal issues, it's like, that's where you put in the do row and the, you know, all that other crap. So that when I'm deposing or cross-examining the defendant on that answer, you know, I mean, look, you agree with me that your lawyers answered this on your behalf, right? Yes. Okay, so you agree you were driving a red car, right? Yep. You agree that you were driving, or that you ran into the back of my client, right? You agree that, you know, my client looked like he was hurt and the ambulance came, right?
Right.
Then you get the answer out and say, well, you know, why did you deny this? You know, why did you say denied or without information, you know, or whatever? And then you start to go into the affirmative defenses where, it's like third party negligence. There's somebody else that's at fault. You start to cross-examine them on that. Who else was at fault? And then the jurors start to understand, look, and I always do a sequence in openings or in voir dire about, frivolous defenses. Frivolous cases. What about frivolous defenses?
Yeah.
Is there another side of the coin where, people come into court through their representatives to try and save money, and they say things that aren't true, and they, and really have a good dialogue about that, so that when I start talking about these things, to help the jurors understand, like, oh hell, this guy, when he answered, he's actually blaming the plaintiff for causing the crash. Because you look at affirmative defense number 5, and it's like the plaintiff was more negligent than the defendant. And so that's one of the things that I've tried to do in a lot of my rear end and auto cases, is especially the low impact cases, is because you have to get the jurors kind of ticked off. I mean, they see the property damage, and that's always something that's really tough. And so I always go through that litigation kind of process, and how when it's just the plaintiff and the defendant admits, but the second the lawyers get involved, now all of a sudden all the denials come. Now all of a sudden all this other stuff comes. Now all of a sudden we're here in trial, wasting everybody's time, and hopefully they start to see, some of what's going on.
Yeah, I think that's phenomenal. I've never thought about it that way. I mean, admittedly, I just, for whatever reason, I haven't tried a lot of, missed type cases, but there's certainly a lot of talk about them. And I have thought about, boy, how do you get the jury to care in a case where it's, the soccer mom who, just wasn't paying attention for a second, and it was, truly easily arguable an accident. Just a really, really tough case. I think that's a really great piece of advice there. One more, just selfish in regards to the opening. Do you typically have like some sort of set starter piece, or is it really specific to your case? And is it really, as far as you approach opening, your starting point is nothing more complicated than, 2/3 focused on the defendant, and then towards the end, a third or so of damages? Do you have any kind of set structure or formats that you incorporate, or things that you always want to include in opening? And if not, that's fine. I just was curious.
I think I always have a segment about just the spine, because I think of the, jury trials I've done, probably 85% of them have been spine injuries, either wrongful death or spine injuries. I think I've done a hip case, a knee case, shoulder case, but the majority of them were spine injuries. And so I usually have a segment in there that's pretty canned, where I just go through the basics of the spine. And ladies and gentlemen, let me just really break this down to make it easy for everyone. This is what you're going to be learning. And by the end of this, you all will be experts. And heck, you might even be able to go in with the doctor and do the surgeries yourself. You're going to learn so much about it, but other than that, nothing, not really that I make sure that I incorporate. It's all kind of just case specific.
Have you ever tried to do an opening more exotic, a la, Mark Lanier, and then I saw Sean Claggett did the, the CSI Las Vegas type presentation?
Yeah. I actually, Sean's a really good buddy of mine. He's a neighbor of mine, and we're really good friends, and we talk and collaborate a lot. I was thinking of doing the CSI for the sportsman's case. And I had actually, one of the things I did in preparation for that opening was I watched all of Mark's openings for the talc cases.
Yeah.
And I actually noted that there was kind of an evolution, if you will. I actually reached out and I don't want to misstate anything, because Mark is, he's Mark Lanier. I mean, my
Another
God,
level. Yeah.
completely another level. So I was curious. I don't know whether he considers it an evolution or not. It was just a change from one of his early openings to the recent, 4 point whatever billion dollar. And in the first case, he didn't spend hardly any time talking about the clients. I mean, it was like 5% of the time, 2% of the time. It was very minimal. Into the next case, he spent a lot of time. He had a lot of clients. And so he spent a lot of time going through each one. You're going to learn about Mary, and Mary is this and this and this. And so I actually reached out to Mark, and he was kind enough to get back to me. And I said, is this something that you intentionally did, that you're now finding it's more effective to spend a little more time talking about the client than just solely focused on the defense? And he was kind enough to respond, like I mentioned, and just said that that he felt like in that case it was important to talk a little bit more about the clients, because he had so many of them. So I think if you can, I guess, help create a connection, a human connection between the jurors and the client, then it's important to do that. But it's often hard to do that in the cases that we have, where it's like a missed case or low impact kind of a case. It's hard to do that in opening, because the jurors, I think, are going to be naturally very, very, very skeptical to begin with. And so I've found that it's better to just kind of wait and present all of the liability stuff and get the jurors really understanding who the problem is. It's not a greedy plaintiff trying to get money. We're just trying to get fair compensation, and the defense is really the one that is dragging this out, that is creating all these unreasonable and frivolous defenses, and then by the time you've kind of primed them, showed them all of that, then you start to transition into who the plaintiff is and why we're here, and hopefully by then too they've got an idea of the process. And so when the defense gets up there and starts hammering your client on all of these little medical records here and medical records there, then they understand, oh, this is just a further continuation of the defense BS, and they're a little more forgiving of your client.
So I've thought a lot about this and had a little bit of an epiphany on it recently. So, I nerd out and watch, CVN a lot.
Yeah.
And which is just an unbelievable resource. Right now, I don't think there's anything better than just being able to watch other people try cases.
Sure.
So I've watched a lot of Michael Goldberg, who's partners with Joe Freed, and he's got several trials on there. And, admittedly, I still pretty much, I follow my version of the reptile, ball outline. I mean, I tweak it and do it to my, add stuff all the time and whatnot, but the skeletal framework is very similar to that. So I was pretty shocked by the type of opening that those guys do, which is the first thing they do is, introduction and talk about a promise of making the trial as short and sweet as possible, as fast as possible. That's their promise. And then the very next thing that they do in almost every one of their openings is they talk about the plaintiff.
Wow.
And they introduce the plaintiff and they describe the plaintiff. And then they get into a story about, what happened. And then they briefly talk about damages, and that's their opening. So I was thinking about that. I mean, well, first of all, obviously there's more than one way to skin a cat, and we know that well now. But I was also thinking that in certain types of cases, I think it makes a ton of sense to introduce your client early on. And
Yeah.
I love premises cases. I don't know why, but I just love them. I always think they're so fascinating. And one of the biggest impediments to winning a premises case is the stigma of your client, that the natural default before they hear anything is that your person's probably a slip and fall artist, and this is a made up or trumped up case, or a lot of bad stuff. And I think that having a good client or credible client, I was thinking when you were talking about the gentleman before that tripped over that post in that case that you almost won, it probably helped that he worked. You know what I mean?
Yeah.
I find that it's incredibly important in those premises cases to have a client that works and have a client that never sued before. Those are your ideals. And I
Yeah.
always ask them, have you ever filed a lawsuit in your entire life before? And I said, no.
Yeah.
And I was thinking that because that, real anti-plaintiff framework is there in juries' minds in those premises cases, those are probably particularly good cases to talk about, the really important qualities of your client early on rather than waiting, because it's going to change the way I think that the people are going to receive the rest of the information. I would not normally do that otherwise, So in medical malpractice cases, I don't think it's as important because, generally speaking, the patient was relatively innocent,
Yeah.
But in those cases where there could be a lot of comparative or a lot of contrib, and people are going to have sort of, different ideas conjuring in their minds of who your client is, it might not be a bad idea to get that kind of stuff out early. And that's also, I have to tell you, we have lousy voir dire here. So I don't
Yeah.
get to talk about anything like that with people ahead of time.
Yeah. So, that is a good point. I do that at the very end, I guess is kind of when I say, now let me tell you who, Nacho is. I had a case, a young man, Ignacio Mendoza, Nacho, he went by Nacho, but that's a case came to my mind. Let me tell you about Nacho. And that's where I kind of plug that in. And at that point, I'll spend some time and I'll really develop the client. When I say, I'll spend a third of the time, the third of my presentation, I guess, would be on, I guess, what do you call it? Vetting your client, creating credibility for your client at that point, and talking about, the good things, he's this, he's that, all of these things. But here's an early influence that I had. So I'm sure Robert Aglet.
Oh yeah.
Amazing lawyer. So I remember that he helped me pick a jury early on in my career. He was, just gracious to do that. We gave him a small percentage, but for what he was earning then to spend the time, it just didn't make a lot of sense for him. He was a great guy to do that. But a story that he told me has always stuck with me, and I'm going to share that with you, for you listeners. And this is why I do it the way that I do it. But he told me of a friend that he had that was an accountant. And his friend basically worked at one of the big regional firms, and they were kind of in school together. They'd gone and done school when he was in the undergraduate, and his friend was in undergraduate, and then he went into the law, and his friend went into accounting, but they stayed friends. And he said this friend, Ben, was the most really kind of OCD person. He was very work ethic, very strong, and he did the exact same thing every day. He would get up and he would be in the office by 8:00, and he would work until 5:00. He'd take a half an hour lunch, and that was it. And because of that work ethic, he started to go up the ranks of the accounting world, and he got he got promoted to manager, and then he got promoted to regional manager of that firm, and he got to a point where now he had multiple people working under him, multiple accountants. And he and his wife, because of the success, they bought a beach house down in San Diego, and they would go down there for the summer. And he would join them every Friday after work. 5:00 would come. He would drive down. He would spend Saturday and Sunday, and then drive home and work Monday through Friday. Well, one day he gets to work, and about 10:00 on Friday afternoon, he says to himself, I'm I'm done with the stuff that I can do. I can delegate the rest of this. I think I'm going to join my wife. And so he calls his wife and says, hey, what do you think if I come down early? And she says, I think that's a great idea. And so he says, okay, where do you want to meet? And she says, well, the kids have got tennis and then they've got soccer. So why don't we meet for dinner at 5 o'clock? And we'll just meet then. And he says, okay. So it only takes, 4 hours to drive to San Diego from Vegas. So he decides, well, I'm going to just take it nice and easy. I've got my convertible, going to enjoy the drive. So he stops at Newport Beach and he's driving down Pacific Coast Highway, stopping here and there. And he says, you know what, I'm going to stop and I want to get just one little taco, a street taco at this restaurant I like. It's just up the road. So he pulls up to the stoplight and he's waiting for it to turn green. When it turns green, he starts to proceed, and all of a sudden, bam, car comes through the red light, hits him and kills him. And so I want you to just finish this sentence, okay? If only. Finish the sentence for me.
Yeah, I mean, I think most people are going to say, if only if only he hadn't done that, if only he hadn't done this or that.
Yeah. So for your listeners, finish the statement, if only. And like Brendan says, the majority of you are going to say, if only he had done X, Y, and Z. But the real answer to that, as we all know, is if only the jerk hadn't run the stoplight. And, then you tell the story in the reverse and you talk about how, Billy was a troubled kid and he was on drugs and blah, blah, blah. And he was working, blah, blah, blah. He and his friends are out all night long. They're partying. They decide they want to go down to the beach. They're coming down the road, run the red light, and hit and kill, the friend. And so when Robert told me that story, I did the same thing. I was like, well, hell, if only he'd stayed in Vegas until 5 o'clock, or if only he'd not done this, or if only he'd have done whatever. And so that's the reason that I really focus on the defense, is just that, that the cognitive biases that we have, you're filling in the information. So I kind of want to tell the story in a way that puts them on blast right off the bat, so that they don't start to fill in their story. But I like the way that you talk about it, and I'll be interested to watch some of these openings by Michael.
Yeah, their whole cases are great and really get me in the right frame of mind to try. And I don't think there's a better allegory for the concept of focus of judgment on the defense at the early stages in particular, and why that's so effective and important than when you hear somebody tell that, from that point of view, that story. It just crystallizes why you need to do it. So yeah. I don't think we're gonna have enough time to get into the nitty gritty of some of your monster verdicts, but maybe I can talk to you another time about that. But what I wanted to ask you is, and keeping with our Mark Lanier discussion, I went down to Lanier's his seminar, the Opening the Vault, a couple of years ago, and it was phenomenal. And I always love when I hear people that they're not content and they're continuing to try to get better. And he was talking about the fact that every trial that he goes into, and this is kind of germane to your point a moment ago, he's always trying to do at least one thing better than he did before. He's trying to add a new thing or try a new thing or improve his PowerPoints or the way he presents something. So with that in mind, with all of your success, and there's no doubt, I'm sure you've got a bunch of trials in the pipeline, or will be trying a lot of cases in the future. Are there any aspects of your, trial chops or presentation or strategy that, you're thinking you want to work on or incorporate or, or try new things?
Every aspect, I think, needs work. I'm always particularly focused on the story. I think that telling the winning story is super important. One resource that I'm going to grab here. I've got to move a couple things to get to it, but one resource that I think is that I always keep close nearby is Winning Case Preparation.
I love that book.
Yeah, just talks about all the different biases, and I think just understanding the different biases, the way that that people make decisions, I think is super duper important. Staying on top of that, and I think the evolution of our society, with just the political stuff and the way that we're kind of becoming even more and more polarized. I think that it's more important now than ever to understand the biases that people have, and being able to identify those, and being able to tell the story in a way that if you're not able to get everyone off the jury that you want to get off the jury, telling a story that will reach a broader perspective, a broader group of folks, that's more universal. It's more of a universal truth. And I think that's along the lines of Rick's moral core advocacy too, is just finding out what is the core of your case, and are you on the right side of the issue?
Yeah, it's funny you bring that up, because that is literally the thing. Although it's the same concept, but the person that got me really thinking about it is Mark Mandel with his case framing.
Yeah, it's great.
And I'd read those books, and I read Advanced Case Framing, and it didn't quite strike me. But then I heard him interviewed by Michael Cowan on Trial Lawyer Nation, and he gave the example, the oft talked about trial of the century in the O.J. Simpson case, and he was asking, what do you think is the what was the case frame? What was the overall case frame of that? And it's, is the glove doesn't fit, you must acquit? Is it a rush to judgment? And he's like, no. What it is, what the overall case frame of that case was wrongful accusation. And the point being that in this day and age, with everybody as polarized as they are, that's a very scary concept for us as plaintiffs' trial lawyers, because you don't want a fractured, you don't want a polarized jury. You want people to be able to come together and all, find a common way, to find for your person. Fractured jury is going to be much more likely to lead to a defense verdict. Yeah. And so there's that concept of, what is it about your case that you can find that has universal application to everybody? And it doesn't just have to be, wrongful accusation, although that's a phenomenal one. But that's what I'm trying to really think about my cases, is to find a way, what is it about this case overall, or where is that presentation or that story or that theme that when I reveal it kind of in closing, everybody can identify with it. Everybody's had that shared experience, that they're all at least on that particular feeling, back to a past experience of their own, they're all going to be able to identify with.
Yeah. Yeah.
I think that's going to be huge to do that, as unfortunately we seem to be becoming more and more polarized as a society. So, well, anyway, Ben, I'm gonna let you go, man. I've picked your brain enough this morning, and I really do appreciate you taking the time out, because I know you got a million things to do, but I learned a ton from this, your wealth of information. So before I sign off, if anybody else wants to call you and find you and pick your brain, or they want help with a case, or they want you to consult on a focus group or something, what's the best way to get a hold of you, Ben?
You just shoot me an email to benjamin.cloward, CLOWARD @gmail.com, or I often give my cell phone out. Feel free to call me anytime. Area code 801-913-5668.
801, that's Salt Lake City, right?
Yes, sir. That's where I'm born and raised, up in Utah. So I just never switched it over.
Gotcha. Well, thanks a ton, man. And I am gonna. Do you have, as an aside, do you have any of your cases that have been on CVN yet?
You know what? I was gonna do this last one, but I just didn't get around to getting it completed getting the request. We had a lot of other irons in the fire, and we had a lot of documents in that case that took a lot of time and prep. I think there were something like 40,000 pages of documents. So I was going to, but just didn't get around to it.
Well, I'm gonna, as a CVN junkie, I'm gonna write to them and say that you gotta follow Ben at this point, because
Okay.
I'd really like to actually see what you're up to in trial, in addition to talking about it. So
Yeah.
thanks so much, Ben. I really appreciate it. And let me just hit the
Thanks for having me, man.
course.